Topic is Criminal Procedure Code in India for the CS executive students. Let us see what are the important points which we have to learn under the Criminal Procedure Code in India. So, as an introduction, CRPC is the law relating to apprehension of criminals. It's about the investigation of the criminal cases and their trial before the criminal courts. So let us see what is meant by an offense. Offenses are what the legislature classifies as punishable. Mens rea or guilt of the person is an essential ingredient of the offense. And there is a legal maxim which says actus non facit reum nisi mens et rea. That means mens rea is the state of mind which accompanies and directs the conduct resulting in actus reus. So mens rea is the mental element and actus reus is the actual action. That means the commitment of the crime. These are the essential factors of an offense. Then offenses are classified into bailable offenses. Bailable means offenses which are mentioned as bailable in first schedule of the CRPC, and other offenses are non-bailable. In bailable offenses, bail we can get as a right. And in the case of non-bailable offenses, it is up to the discretion of the court which is giving the bail. Then comes cognizable offenses. In the case of a cognizable offense, a police officer can arrest without a warrant. And that depends upon the seriousness of the case. And in non-cognizable offenses, a warrant is required to arrest a person. Then comes a term called a complaint. Complaint is nothing but allegations made orally or in writing to the magistrate for taking an action. It does not include a police report filed by the police after an investigation. Complaint in criminal cases is equal to a plaint in civil cases. We have learned what is meant by a plaint in the case of a civil suit under the CPC. Just like a plaint, we have the complaint in the case of a criminal case to initiate action. Let us see what are the essentials of a complaint. A complaint always contains an oral or written allegation, and some persons committing an offense, known or unknown. And it must be made to a magistrate, and it is made with a view that an action may be taken by the magistrate. Then comes the word bail. Bail is the release of the accused from the custody of the officers of law to the private custody of the sureties to produce the accused to answer the charge at the stipulated time or date. There is a word called anticipatory bail that is granted by the High Court or Sessions Court to a person who is facing arrest for having committed a non-bailable offense but has not been arrested. An opportunity of hearing is given to opposite party before granting bail. Then comes enquiry. An enquiry is wider than a trial. An enquiry stops when the trial begins. Enquiry is conducted by a magistrate's court. Then comes investigation. All the proceedings for the collection of evidence by a police officer or any other person authorized by a magistrate is called an investigation. Now let us see the stages of a criminal case. A criminal case starts with investigation by the police. It proceeds with the trial or enquiry. Judicial proceedings means enquiry and trial. Pleader is a person who is authorized to practice in a court. It can be a non-legal person also appointed with the permission of a court. Public prosecutor conducts the case for the state. And warrant case is a case which is relating to an offense punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. Other cases are called as summons cases. The division of the cases into summons cases and warrant cases is based on punishment. Summons case dealt in Chapter 20 and warrant case in Chapter 29 of the CRPC. Then the hierarchy of the criminal courts are there. We are having executive magistrates, then judicial magistrates of the second class, judicial magistrates of the first class and metropolitan magistrates, chief judicial magistrate or chief metropolitan magistrates, courts of session, high court. Under any other law, special courts also can be constituted. Appellate power of the Supreme Court on criminal matters from a high court given under Article 134. So this is the hierarchy of the criminal courts in our country. At the apex, we are having the Supreme Court at the helm. We are having the executive magistrates who are not in the category of the judicial magistrates, but they are given certain powers. And at the lowest rank, we are having the judicial magistrates of the second class, then judicial magistrates of the first class, above them CJM or CMM, then courts of session, then the high court, which is the highest court in the case of a state. All the states in India are having a high court, and for some 2 states, one high court is there. Then, power of the courts. The power of the court is to try offences. It can be under IPC, that is Indian Penal Code, or any other law. Then to pass sentences. The High Court and the Sessions Court can pass any sentence, including death sentence. Death sentence by Sessions Court are subjected to confirmation by the High Court. They have the power to pronounce the judgment, but the death sentence made by a Sessions Court is subjected to confirmation by the High Court. An assistant sessions judge cannot pass death sentences because they are coming lower in hierarchy when it comes to the Sessions Court. Sentences which magistrate may pass are mentioned under section 29. And CJM, imprisonment up to 7 years. Then comes magistrates of the first class up to 3 years and fine up to rupees 5,000. Magistrate of the second class up to 1 year and fine up to rupees 1,000. Chief Metropolitan Magistrate is having same powers as that of the Chief Judicial Magistrates. The Metropolitan Magistrate is having same powers that of the Judicial Magistrate first class. And the third is the sentence of imprisonment in default of fine, which is falling under section 30. It does not exceed 1/4 of the term up to which the magistrate can pass sentence. And sentence in case of conviction of several offences at one trial falling under section 31. Then comes a term called arrest of persons. Arrest of persons can be made without an order from a magistrate and without a warrant. Arrest on refusal to give name and residence of the person in non-cognizable cases, even when false name and address is given. He is produced before the magistrate within 24 hours. Arrest can be made by a private person also, like us. In the case of cognizable offences, non-bailable offences, and when he is a proclaimed offender. Arrest by a magistrate. Men of armed forces can be arrested only with the consent of the central government. So this is one condition. And how the arrest is made? The purpose of arrest is to take into custody. That means take the person into custody. And what is the purpose of an arrest? To make him answer a charge or to prevent the commission of a crime. The detention of a person is to restrain his movement. And let us see the general processes to compel appearance under the CRPC. The first is the summons. There are certain conditions attached to the summons. It must be in writing. It must be given in duplicate, signed by the authorized person, and it specifies the court, place, date, and time of the appearance of the parties. A summons is sent to accused, to some witnesses, to appear or to produce a document before the court. How the summons are served? Summons may be served by a police officer, officer of a court, or other public servant. If the person is not found, it is affixed at a conspicuous part of the house. And if the court is satisfied that it is duly served, it may declare to that effect or release a fresh one. Summons to corporate bodies is the next area. When summons is sent to the corporate bodies, it is sent to the company secretary, manager or principal officer of the corporation, sent by registered post to the chief officer of the corporation in India. Corporation also includes a society registered under the Societies Act. Then comes personal service. If personal service cannot be made, an extended service may be given to some adult male member of his family and not a servant. You have to remember, to some adult male member of the family and not a servant. In the case of a government servant, to the head of the office. Then comes the warrant of arrest. In writing, bear the name and signature of the person who is to execute it. Give full name and description of the person to be arrested. State the offense charged. Must be signed by the presiding officer. And it must be sealed. So these are the conditions. And what is the purpose of a warrant? For the production of the person before the court concerned. Without any delay, the person is brought to the court within 24 hours of arrest. The time taken to travel from the place of arrest to the magistrate court is excluded. Suppose the crime has happened in Trivandrum and the accused is in Delhi. The accused will be arrested from Delhi, and the time taken to travel from Delhi to Trivandrum is reduced from the 24 hours of time and remains in force until it is cancelled by the concerned court or until it remains unexecuted. Then proclamation and attachment. In the case of a person absconding or concealing himself to escape from the law, the court may proclaim his presence at a specified place and date not less than 30 days from the date of the proclamation. It is actually to make a person come before the court that such a proclamation is made. The object is to compel presence and not to punish the person. Then comes search warrant. When the court is of the opinion that a document or thing summoned may not be produced, or when it is known to the court with whom it remains, that means when it is not known to the court with whom it remains, when a general inspection is necessary, when a person is unlawfully confined, the district magistrate, subdivisional magistrate, or first class magistrate has power to issue a search warrant for the search of the person. As a security for keeping peace on conviction also, the magistrate can order him to execute a bond for 3 years with or without sureties. Then security for keeping peace in other cases, the executive magistrate may order to execute a bond for 1 year. Unlawful assembly. What is meant by that? When 5 or more persons assemble, executive magistrate or person in charge or in absence, person not below the rank of an SI can order dispersal of the assembly. If the assembly is not dispersed, forcefully it can be dispersed by the police officer and may be the parties concerned. The help of the armed forces may be sought. Police has the power to prevent commission of a cognizable offense by arresting a person and keeping him in custody for 24 hours and more than that in certain cases. Then inspection of weights and measures by the police officers. What is an FIR? First Information Report. It is the information given to the police about the commission of a cognizable offense. It sets the criminal law in motion. After recording the FIR in a book kept at the station, a copy is given to the informant free of charge. If any officer in charge of the police station do not write down the information, FIR may be sent in writing to the superintendent of police. In the case of cognizable offences, magistrate order an investigation. In non-cognizable offences, it is mandatory to get an order of the magistrate. When 2 or more cases are there and at least one of them cognizable, the whole case is treated as cognizable. What is meant by investigation? It means collecting evidence. Search by a police officer when there is the need of a document is to be collected. And the reasons are recorded in writing. Then what is the meaning of taking cognizance? A magistrate can take cognizance of a case when a complaint is filed before the magistrate's court on the report of a police officer, when informed by any other person or his own knowledge. When informed by any other person or on his own knowledge, the case may be transferred to a magistrate as directed by the CJM, Chief Judicial Magistrate. Courts of session not take cognizance of an offence. Additional and assistant session judge may buy the case as committed by a magistrate. May try the case as committed by a magistrate. Then comes the limitation period for taking cognizance of certain offences. The limitation period is specified in the Limitation Act, Chapter 36, introduced to specify the limitation period. In the case of crimes, when the punishment is fine only, 6 months is the limitation period. When punishment of imprisonment up to 1 year, 1 year is the limitation period. Punishment of 1 to 3 years, 3 years is the limitation period. When more than one offence is combined together, gravity of the offence determines the limitation. When does the period of limitation commence? From the day offence is committed. when it is made known to the aggrieved party or the police officer, whichever is earlier. When the identity of the offender is known to the aggrieved person. And there are certain exclusions to this main principle. When another prosecution executed relating to the same facts, period of stay or injunction against the prosecution exists, the period of notice to the prosecution, when sanction is necessary for the prosecution, the period of sanction, when offender is absent from India, when he is concealing himself or absconding, when limitation expires on the closing day of court, it commences on the date of reopening of the court. In the case of continuing offenses, every moment at which it continues. Period of limitation may be extended by the court on sufficient reasons and when it is necessary in the interests of justice. Then comes the provisions relating to summary trials. The purpose of a summary trial is the speedy disposal of the cases. The procedure is simplified in the case of a summary trial. Recording of the trial is done summarily. Small offenses only are tried under the summary trial. Complicated ones reserved for summons or warrant trials. Section 261. CJM, magistrate or first class magistrate may try. Metropolitan magistrate or first class magistrate, I mean. Apply to offences not punishable with a term exceeding 2 years. Theft, falling under section 379, when the property value does not exceed rupees 200. Receiving or retaining stolen property. Assist in concealing or disposal of stolen property. Offences under sections 454 and 456. Insult with an intent to provoke, breach of peace. Abetment of any of the offences. Attempt to commit any of the offences. Abetment means helping. Attempt means you are trying to commit the offence. Offences under complaint under section 20 Cattle Trespass Act 1871. Maximum 3 months imprisonment is provided as the punishment. And when there is a summary trial, we have to keep the record of serial number of the case, date of commission of the offense, date of the report or complaint. Report means the police report. The name of the complainant. Complainant means the person who is filing a complaint before a court. Name, parentage and residence of the accused. This is to get the identity of the accused. An offence complained of and proved, the value of property under offence. Plea of the accused and his examination, if any. Then the findings, sentence or other final order, the date on which proceedings terminated. A register containing all this forms the record of a summary trial. Then comes judgment. When accused does not plead guilty, the magistrate records the substance of evidence and a judgment containing reasons for such findings. Then the magistrate signs the record. So this is all we have to learn under the